The sitting is resumed. Honourable for Christchurch East.
Sir, I rise to add to this cognate debate on what I consider to be 5 very important steps towards leveling the playing field, correcting some things that were wrong, and putting the police, the judicial system, and the whole criminal justice system on a relatively good footing. What I did not expect, sir, was to come after such a presentation as the last one by the Honourable Leader of the Opposition. I commended the AG, sir, the Honourable Attorney General, after his presentation, because while we have had a number of cognate debates in here, I can't recall one. I think when we did the suite of business legislation, when the Honourable Ronald Toppin was the minister, we had a suite in a cognate debate, but outside of that, I cannot remember us dealing with 5 pieces of legislation in one debate, 3 new and 2 amendments. And I commended the AG for the fact that he was able to deliver, touch on all, and show the link. And I then waited with some level of anticipation to hear what the Honourable Member for Christchurch South was going to say, because he's not necessarily known to be one with structured responses. And I was curious to find out how he was going to tie the 5 together, and I was not disappointed he didn't. What we were treated to, sir, was, I can't even, somewhere in there tuned out. I cannot even recall the length of it, but we were treated to a diatribe effectively on one subject. And after a while, it dawned on me, and I'm sure it dawned on other people who were listening, that the reason we had the concentration on the one subject was because he was woefully unprepared for the others. So he could not, the Honourable Leader of the Opposition did not touch upon the jury's legislation, because he probably was not prepared to deal with it. He couldn't touch on the amendments to the Police Act because he probably was not prepared to deal with that. He could not touch on the witness anonymity. I mean, I would have thought that as an officer of the court and somebody practiced and steeped in the law and courtroom procedure, that would have been, that's a game changer there. That's novel, cutting edge legislation. I would have thought he would have something to say on that. Nary a word. So the firearms amendment, the explanation and rationale given was, this thing has been amended so many times that, and it probably going to be amended again, that he need not touch on it. And he spent his entire presentation, sir, on the wireless, the interception of communication. And what struck me, he kept saying, show me a democracy and I will show you a tyranny in the making. He kept saying it. He kept saying it, sir. He needs to extend that. Show me a man who pulls the grenade pin, throws it up in the air behind him, and walks and leaves it, and I will show you a coward. Because I expected at the end of this break to fully respond to the Honourable Member for Christchurch South and to confront him on his misrepresentations, on his salacious comments, on his inflammatory innuendos, on everything that he did, and to give him a chance to respond and interrupt me on anything that I said was wrong. Sir, we took a decision, in case people who are watching say to themselves, nobody said anything, so everything he said must be true. We took a decision to not interrupt the Honourable Leader of the Opposition in his presentation. Because we have realized, sir, especially when he comes completely unprepared, that interrupting him gives him fodder. It gives him something to latch onto in the interruptions that allow him to flesh out even more time without adding to substance. I must say, sir, that I am exceedingly disappointed. I sat down here and I watched other persons. I watched some in the gallery from his own team, and I saw them shaking their heads as well as he went off on a tangent of his own. So if you ever saw a pop kite, you see a kite snaking on the end of a cord, sir, and then the kite pops. You have no idea where it's going. You have no idea how far it's going, and all you do is hope they don't fall and land and hit an old person. And that was my fear in this. It was perhaps the most irresponsible speech and presentation that I have heard since this parliament started to sit back in 2018. I have never heard anything like that in my entire time listening to any debate anywhere. I would almost say, sir, is reflective of our brothers and sisters from the north. But I think even they would be hard-pressed to find a speech so wrapped up in vitriol and inexactitudes that it does not even pause to pay fleeting reference to the truth. It was fear-mongering at its extreme. That speech, sir, by the Honourable Leader of the Opposition was meant solely to cast fear amongst the public and to create an us and them situation or perception, where the us on his side being him and Barbados, and the them being the government. I urge anyone who was listening to engage their common sense. Engage their common sense, sir, and apply it when listening to what was said. The press, sir, reports, they have to carry what the lead opposition said. They have to carry what the principal speaker said, in this case the Attorney General, and they have to carry remarks from the leader of opposition. And it is likely that some of what he says is going to find itself into the press tomorrow. It was irresponsible in the extreme. If we strip it down, sir, let's say anything in there he said had a basis of truth. Then it is saying to the criminal element in Barbados, I got all I wanna. I got all I wanna. I am going to protect you at all costs. This is the same person that comes ad nauseum to talk about crime in Barbados. This is the same person that was pushing a criminal report and something, I can't remember what they call it, that I actually scanned through it and I thought to myself, they really sat and wasted time doing that. It was embarrassing and it was disappointing for someone, anybody who's the leading opposition, contemplates at some point in time that they're going to lead a country. If this or that is what the option is, sir, we're in a sorry state. We are in a sorry state. Sir, let us talk about interception of communications. You know, sir, I know the AG said it, he led off with it, the leading opposition led off with it. We know where tapping happens. It has happened from the time you were practicing, you started practicing criminal law, sir, before it predated all of us. We don't necessarily understand how it works, but we know it happens. At no point in time was this government trying to say, we got something on you. Well, sir, we would have to be the most foolish government in the history of governments to be trying to capture people or pull one up on people and legislate it and then talk about it. It occurred without legislation. It occurred unsupervised and unregulated. Nobody knows exactly how far the police have gone with this up to this point in time. They were not required to get a warrant. There was no oversight on it. We know it occurred. We have now brought legislation to protect the people of Barbados. Protect the institutions. We have now said you can't do it because you feel like it. You can't do it and we don't know what you're doing. Yes, we accept that sometimes you will need to gather evidence by interception. I'm just going to call it wiretapping because that's easy. That's just easy for me. It rolls off my tongue better. We know you may have to gather evidence by wiretapping. But you, before you need to do it, have to go and request a warrant. Get a warrant from the Chief Justice. There must be judicial oversight, not ministerial oversight. There must be judicial oversight. Not come and get the blessing of the Attorney General. Not come and get the blessing of the Prime Minister. Not come and get a blessing from a ministerial subcommittee. You have to go to the highest legal office in the land, that of the Chief Justice of Barbados, to get your warrant. Not an ordinary judge. Not a magistrate, not a JP, no less a person than the Chief Justice of Barbados, the police or whoever is the two office holders, and not even just a general police officer. So Sergeant Blackman, I don't know that is a Sergeant Blackman in Blackrock, but Sergeant Blackman from Blackrock cannot take it upon himself to go and speak to a magistrate to get permission to tap my phone. If Sergeant Blackman feels my phone needs tapping, Sergeant Blackman must convince the Commissioner of Police or the Director for the Anti-Terrorism. He must convince them. They then go and make the application. The two highest persons at the level of crime investigation in Barbados, they have to go and make the application to the highest judicial officer in the land and convince him. Only on convincing the Chief Justice do you then get the permission to go and intercept somebody's communication. As it stands now, we have no idea what the requirement for the police officers are to get permission to tap your phone. We have no idea how long they do it for. We have no idea of the reasons that they have to tender or who they need to satisfy to get it done. We have no idea who they're doing it to. So this government said we are in a fight against crime. There are things we accept that we need to do. There's a whole raft involved in this singular debate here. But let us do it properly. Let us A, tell people we can do it. Let us B, tell people how it is to be done. Let us C, tell people who can authorize it. Let us D, tell people how long it can be authorized for. Sir, if that is the action of a government trying to pull one over on people and pry into people's personal business, then we're going about this all wrong, sir. All wrong. We could have said nothing and allowed it to continue as it was. Nothing at all. So the insistence that this is the government trying to rule by fear, the insistence that this is the government trying to pry into the lives, the personal lives of people and get into business, the insistence that this is the government trying to suppress political will in this country is foolishness. It is absolutely reckless. This government does not try to stop anybody from speaking. People have their full say on the government. People on loose out the mouth on the government every day. We know who the players are. You don't hear anybody is targeting them or trying to curtail them. I mean, if they get into defamation, that's something else. But people have their full free say without interference by this government. And the other thing as well, sir, some of the statements made in here today, sir, I don't know if I say borderline defamatory. Some of them are defamatory. What was said in here could only be said by the Honourable Member for Christchurch South inside this chamber. because he cannot be prosecuted for what he says in here, and he fully well knows that. If he is so convinced about what he's saying, if he is so convinced about the rationale, and he wishes to pull out and call the names as he did in here, and the office holders in here, let him say that from George Street. Let him say that on a platform. Let him go and say that to the media. He can't do it. If there are things you can only say in here that you can't say outside, it means you're depending on the protections afforded by the office that you hold. And if that is what you're doing, that is an abuse of the privileges of this chamber, sir. An abuse of the protections of this chamber. I had to go across to the Honourable Attorney General while the Leader of Opposition was speaking. I said to him, we need to interrupt. He is misleading. I was told, leave him alone to his own devices. Deal with him after. Do not interrupt him and give him something else to say. Let him say what he has to say. The public of Barbados is listening, and they will judge him. Well, I am glad, sir. To be honest, I get very sage advice from the Honourable Attorney General all the time. Because I was prepared to deal with him, sir, as for him to be able to say again, how you getting this? How you getting this? But, sir, if I go to the legislation itself, the Juries Act, a critical one, was raised by the Honourable Attorney General, and that is the disparity in the composition of the juries for murders and other offences. And that was one that begged a while, sir, for some consolidation. Now, I don't think people actually understand what the repercussions are. If murder is tried by a jury of 12 persons, other criminal offences are tried by a jury of 9 persons. So, if a crime happens where somebody died, you need to decide in the trial whether you're going for the lesser offenses or whether you're going for murder, because it affects the composition of the jury. If you throw everything behind murder and the person is tried for murder and for some reason they get off murder, but all the other ingredients for the lesser offenses were there, they cannot be found guilty in the course of that trial, although all of the evidence points to the fact that I had a gun, that I did some other violence, that I broke and entered. All the other offenses there, you skin it or you hang it all on the murder charge. And because, sir, of the usual consequences for murder, then the standard of proof is proof beyond a reasonable doubt, sir, but it goes past that because of what the consequences were. So I am glad that we have now consolidated that. The bar has been crying for that for a while, right? We've mooted this, we've dealt with this, we accepted it was a loophole, that it was a shortcoming in legislation, and it's taken us a while to get here, but we have gotten here, sir, and this, I think, plugs a hole to allow for greater efficacies for trials. When somebody, you could throw the book at somebody now. When they have done a series of offenses culminating in death, you can try them for all at the one time. They stand trial for all. So even if you get off of the heaviest one, you stand still to be convicted of the others in the same trial. And I think that is a great, great plus for us, sir. Sir, the witness anonymity, I am surprised, as I said, that was not touched on by the Honourable Leader of the Opposition. Some people may say, I have a right to see who's confronting me. I have a right to see who's accusing me, right? But it is not only for the complainants, it also deals with witnesses. And in many situations, in particular, sir, sexual situations which occur in families, a family member may inform on another family member, but they obviously do not want to be the one giving the evidence. They don't want to be the one giving the evidence in case the person gets off. They don't want to be the one giving the evidence in case the person is convicted. You then become the person who sent Uncle Sammy to jail, right? You then become the person who broke up the family. So they may for whatever reason, wish to be able to give that evidence anonymously. It does not defeat the level of the evidence. The judge can make whatever ruling that they want, or make whatever direction they want to the jury with respect to the evidence being given anonymously. There are safeguards in place to ensure that the person is not a fictitious person, right? And this exists in other jurisdictions. I just picked one thing out of it. But equally, sir, I had a situation in Christchurch East where somebody was doing something very foolish. And two different people called me. And they said, this person is out there doing something very foolish at the moment. And I asked, have you called the police? And the person said, no, we called you. I don't want to get in that. That is what the person said. I don't want to get in that. I, as an MP, can't pretend that the foolishness was not going on. But, sir, if you have a situation where persons can actually go and get evidence, give evidence, and have their identity protected, we might actually end up with more cases not suffering from the lack of evidence. Because quite often the prosecution cases fail for one principal reason: lack of evidence. Either the complainant is afraid to testify, either a critical witness who saw the incident is afraid to testify, afraid of repercussions, right? And this exists. We are not creating something new. We are catching up, sir, with a lot of progressive jurisdictions in our prosecution of criminal trials. So I am glad that this is included here as well. Firearms Amendment. People hear about ghost guns and 3D printing guns. What happens, sir, is a lot of the firearms that come into Barbados, or a lot of firearms that exist out there, the major parts that can evade detection are polymer based. You require metal for the barrel. You may require metal for certain component parts, small parts inside the gun. If you ship a whole gun, a scanner is going to pick up a whole gun. Even if it picks up the plastic and whatever, it's going to pick up an entire gun. So what people then do, sir, is send the gun in parts. You send the trigger one way, you send the housing, the slide somewhere else in a bunch of other metal parts that it can get lost in the scanner on. And when the gun arrives at its destination, you assemble the gun. You may even 3D print the base of the gun, the grip and the rest of it, and the frame of the gun. So if somebody intercepts a shipment that has in a barrel and a slide, then what? You don't have the whole gun? If somebody intercepts somebody's bike coming through the airport with a magazine in it, you do not need a magazine if you don't have a firearm. So you bringing that magazine into the country contemplates that at some point in time that magazine is going to butt up with a firearm designed to carry that magazine. It is not sufficient for me to say that I have a 9mm gun, so I'm entitled to have magazines. If I have a magazine that's not compatible with the firearm that I have, that magazine was intended for somewhere else. It puts the person to proof as to why they had it. So I also completely agree with this. And the comment was made by the Honourable Leader of the Opposition that they had a number of amendments to firearms legislation, but they're going to be, as the firearms evolve, you have to amend the legislation. As the methods of shipping and smuggling the parts evolve, you have to amend the legislation. As criminals get more creative, you have to close the loopholes that their creativity opens. So, to me, the multiple amendments to a piece of legislation shows that we are actually on top of what the piece of legislation is supposed to be doing and being proactive in terms of shutting down loopholes as soon as they arise. So once again, this is just another step in making sure that the legislation is contemporary, it makes sense, and it caters, sir, for everything that we hope to track by virtue of firearm legislation. Sir, the Juries Act, the AG dealt with that completely fully, sir. We do have increased penalties and increased penalties for intimidating witnesses and trying to influence witnesses. The penalties are actually quite severe, designed to discourage. We anecdotally know of persons being approached to not give evidence, persons being approached with threats to their families. I'm saying anecdotally because I don't wish to be pinned to anything, sir, right? But we know it happens. People trying to influence jurors to not give evidence. Well, the penalties, sir, attached to the persons who try to influence and also the jurors, if they do accept the influence, are severe enough to make anybody really think about what it is that they're doing. I understand that we're being very serious. We're trying to tighten all of the gaps that allow people to escape from our criminal justice system, and this is another one. Sir, the Police Amendment Bill, I am glad that we're actually dealing seriously with the island constables. The persons who have been island constables for a while, and special constables for a while. And the Prime Minister always said, you know, the different types of qualifications. The paper qualifications and then the experience qualifications. And if somebody has been acting and working alongside a police constable and doing what the police constable does for a period of 3 to 5 years or more, then although that person may not have had the requisite CXCs for entry or the requisite qualifications for entry, after 5 years, I dare say that they're in a position where they can adequately perform the function, otherwise they wouldn't still be there. So by recognizing this is just, sir, in keeping with what our government has said over and over, that we deal with qualifications wherever they arise, whether paper qualifications, whether experience qualifications, or whether special skill set qualifications. I also, sir, firmly agree. I know of the person from Jamaica who is a forensic expert, who is paralyzed from the waist down, and they would not normally be able to be a regular part of the police force and draw a police force salary or get the benefits that accrue to being a police officer. But this is something that we have to look at as well. Policing is now to the point, sir, that you cannot measure everybody by one stick. So those involved in cybercrime need to have cybercrime training. And I might be able to decipher code or I'm a bit out of my depth in this explanation, so I hope this is making sense, but I might be able to decipher code, but I can't run 5 miles. So because I can't run 5 miles means I should not be a police officer, when quite frankly you need me for my ability to crack codes more than my ability to rumble and try to catch somebody jumping over a fence. So it makes perfect sense. Horses for courses. Anecdotally, sir, a lot of people don't realize why there used to be a standard for size for police officers and military officers and whatnot. One had to do with physical fitness, but another one, sir, was the simplicity, something as simple as uniforms. It narrowed the range of uniforms that you had. You could get medium and large as opposed to extra small, small, medium, large, extra large, double extra large, triple extra large, whatnot. So some of the things we've held on to, don't make sense anymore, but we have them because they have not yet been changed. And one of those, sir, is the size requirements for certain occupations, and those were all uniform occupations, sir, and it was just easier to have the uniforms pretty much made to a standard size. So that does not make sense anymore, and I agree with the AG. Let us find the skill sets where they are. Let us hire the persons into the police force. Let us pick the horses for the courses that we want them to run, as opposed to painting everybody with the same brush. For example, even the cybercrime person. If you wish to be a cybercrime officer attached to a special cybercrime unit, your requirements academically or qualifications might actually be higher. You might have to have a PhD or a master's. You might not be able to run 5 miles, but instead of getting in or 3 or 4 CXCs, you now have to have a doctorate. So let us pick the persons and pick the qualifications to match the skill sets that we actually require. So, sir, the Honourable Leader Opposition also said that the new Bail Act was a complete failure because the Bail Act was meant to stop persons who have convictions or who are associated with criminal activity from being on bail. So we're the legislature. He wishes to talk about separation of powers. We make the laws. The judiciary interprets those and applies those. We can make whatever laws we want, but if the judges insist on giving bail to persons, then there is nothing that we can do from this end. So if you wish to point at the Bail Act being a failure, and I do not agree that it is, I will say that the contemplated application of the Bail Act did not translate into reality. And we may have to look at the way the judiciary approaches that, but it can't be a hands down. It can't be a dictate from the Attorney General. That has to be something that is dealt with by the judiciary of their own recognizance. So I do not agree with him on that at all. And he wished to talk about his notes, and he was going back to his notes, and he quoted extensively the Honourable Attorney General. I wish to quote something that I cannot believe he said. If we go back to the interception of communication, the words were, "No one, even somebody connected with crime, deserves that sort of treatment and surveillance, even by telephone." I could not believe that I heard those words coming from the mouth of the leader of the opposition. No one, even somebody connected with crime, deserves that sort of treatment, ... including surveillance by telephone. Sir, I think that he started to speak and his mouth ran away with him. I think he started to speak, sir, and the words outstripped the process, the synapses that need to be firing to actually connect cohesive thought with spoken word. I believe, sir, that the leader of the opposition could have helped himself by preparing. Yes. He could have helped himself by preparing. Yep. The Honourable AG came in here and did a cognate debate of 5 pieces of legislation. 3 new ones, 2 amendments. He did it in a fluent, cohesive manner because he prepared. I know he prepared because he sent us all briefs. We all got the very plain, simple, easy to understand, easy to follow briefs on the legislation. So I know he was prepared. The fact that he was insulted by a response that concentrated on one aspect and ignoring all of the rest, and not even concentrating on that aspect, sir, with the purpose of dissecting the legislation and suggesting proper changes, but simply to raise fear among Barbadians, as the Honourable Leader of the Opposition seems to have made it his mission to do. Come in here and stir it up. Stir up, make the pot boil, impute all of the negatives on behalf of the government. Impute all of the fear. The government is trying to get your business. The government is trying to stop you. The government is trying to tie your hands. The government is trying to monitor your calls. The government is trying to monitor where you go. The government is trying to stay in your car. The government is trying to take down your curtains that look in your house. The government is trying to do this. The government is trying to do that. And actually contributing nothing to the substance of the legislation coming out of this parliament is disingenuous in the extreme, sir. And I think it is borderline. Actually, it's not borderline. It is dangerous. It is an irresponsible act from a person constitutionally recognized and a person with high power. It is an irresponsible act from the person who heads the other major political party in Barbados. It is an irresponsible act from the person who gets the second most press coverage in Barbados. He knows what it is he's entitled to. He knows what it is he gets, and he must wield that responsibility. He keeps saying, show me a democracy, and I'll show you a dictatorship in the making. Then, sir, he needs to look in the mirror and recognize who he is, what he stands for, what he represents in the landscape of Barbados, and then do what is best in the interest of Barbados and not solely his own political preservation. Sir, with those few words, I thank you.
Honourable Prime Minister.
Thank you very much, Mr. Speaker. I rise to participate in this debate and to share some perspectives that I believe to be appropriate as to the perspective of government, as to the intention of government, and as to our communication and partnerships in seeking to bring together for the third time since assuming office as the government of this country in May of 2018, a national approach to a national problem. What is immediately before this honorable chamber today are 5 pieces of legislation being taken as a cognate debate: a new wireless interception bill, a new juries bill, a new criminal procedure witness anonymity bill, amendments to the Police Act, and amendments to the Firearms Act. And Mr. Speaker, I simply make the point that I want at the outset to commend the Attorney General, the Honourable Attorney General, the Chief Parliamentary Counsel, and the members of their department for putting this honourable chamber in a position to be able to treat to the clear difficulty and challenge that this country faces with respect to the maintenance of a safe environment across the board. And I thank them for these pieces of legislation because they come on top of much other work that has been done. And you may recall that there was a national consultation on criminal justice reform within the last 18 months, 2 days of consultation, if I am to remember appropriately and correctly. And we recognize that there were anachronistic systems and anachronistic pieces of legislation that needed to be addressed. Separate from those consultations at the national level, which were broad-based, including members of the legal profession right across to those who work within the social services of this country. In addition to those national consultations, we had the honor of participating in a regional heads of government meeting, 2 of them, one in Trinidad and Tobago and one in November last year in Georgetown, Guyana, that was actually supposed to be in Barbados, but we shifted it to Guyana at the last minute. And out of that last meeting came a number of critical decisions embodied in the George Bridge Declaration and reflecting and improving also the issue of our position on the Needham's Point Declaration, to which the Honourable Attorney General spoke today. I just start to give that contextual framework at the outset of my speech so that persons understand the framework within which we started. But the government has not stopped there. Over the course of the last 6 weeks, we have been meeting with the social partnership of this country. We have in fact expanded the meetings with the social partnership to include the Social Justice Committee, which invariably involves not just the Barbados Christian Council, the Barbados Evangelical Association, but also the Social Workers Associations, MESA, and a number of other NGOs that are there. And the government did this while at the same time extending a hand to the opposition to be part and parcel of this process. And more specifically, in the context of the participation in the Advisory Council on Citizen Security. Now, Mr. Speaker, it is perhaps a matter for which many of us, not just myself, regret that the opposition has chosen to take a partisan approach in these matters pertaining to life and death and national development in this country in circumstances where the government, for the third time since assuming office, is trying to establish a national approach to a national problem. An approach that goes beyond the government of Barbados as a player. When we confronted our issues upon assumption of office with respect to debt, when 69 cents in every dollar was going to service debt and not be able to do substantive programming or activities within the government of Barbados as it was then, we had a national approach. And I stand here today as Prime Minister proud that after 7 years of working with the IMF, largely because of the initial 4-year program and then the second 3-year program coming in the middle of COVID, that we are in a position now where this country has virtually reduced our debt. In absolute terms, it is still $3 billion less than it was when we took over. As a ratio, it has gone from 177% with respect to all the public debt and all that we owed through adversarial financing, as we called it, from 177% debt to GDP ratio to 102%, and we are scheduled to go below the 3 digits by the end of this year. Mr. Speaker, we set a national framework to address a national crisis with our economy and our fiscal circumstances. And Mr. Speaker, it is fair to say that with the help of the social partnership, with the help of the Social Justice Committee, with the sharing of the burden by all Barbadians, we succeeded. We are now in the process of mission transformation because the structures that we have and the economy that we have needs to transform itself, particularly given the polycrisis that we face, whether it is the climate crisis, whether it is the geopolitics, whether it is the supply and logistics crisis, whether it is the skills deficit crisis, whatever crisis it is, whether it is even the challenge of crime and gun crime in particular across this region. In 2020, we had a similar national challenge, and that challenge was the first major pandemic for 100 years. And I want to thank Verla de Pisa. I did not give notice of her name, for rising above the voices that surely would have been telling her, you do not go and participate with a government that you need to oppose. And I want to thank her for having the courage to be able to find common purpose with the people of this country and the government of this country at a time of great crisis when tens of thousands lost their jobs, when people were restricted in their movement, when fear gripped the society. And she, along with the church, the other religious groups, the social partnership, we gathered at the Hilton Hotel and we addressed the country together to confront a national problem in a mature manner. And Mr. Speaker, it is to my greatest regret that we lost lives. It is to my greatest regret that people have suffered from that pandemic in multiple ways, from physical impairment to mental impairment to bereavement to loss of jobs to loss of property. But for the most part, Mr. Speaker, all will say we contained the scale of the losses as much as we could humanly do because of finding common purpose in the battle. You will forgive me for being very deliberate this afternoon in speaking in this way. There are not many things that I may proffer some advice on to the country for the times when all of us may have gone. But this country, for it to continue to be exceptional, for us to have persons talk about the idea of Barbados, it is because, irrespective of the different political parties that have had the honor and privilege of leading this country, there have been certain things that have always been sacrosanct. I thanked Verla de Pisa just now. I am old enough with enough gray hair in this chamber to remind us of my thanking the late David Thompson more than once, on two grounds, neither of which ultimately became as challenging and catastrophic in damage and injury to this country than those last two that I spoke that this government has to confront. But nevertheless, critical to the stability of this nation, I refer to our joining the Caribbean Court of Justice. And when other countries across the region continue to suffer from division between government and opposition, David Thompson rose to the occasion and agreed with us that the Caribbean Court of Justice should become this country's final court of appeal. Similarly, when we, and the member for St. James Central will recall this, took the decision to invoke arbitral proceedings under the United Nations Convention of the Law of the Sea against our very close family, our sisters in sister government of Trinidad and Tobago, David Thompson also took special briefings. I know, because I was with Prime Minister Arthur when those special briefings were being given, because I was the Honourable Attorney General at the time, and therefore was required to provide the briefs. And yet again, there was common purpose ultimately in that. There was conversations before that about solving the problem over Bola Cuckoo in Glenburnie. But when the real time, and I to give context, but when the rubber hit the road and national interest came to be regarded, we came together as one. I go far further. In that first term I spent in this parliament in 1994 to 99, The Honourable Branford Tate, who later became President of the Senate under the Democratic Labour Party, was in opposition at that time. And we came together in common purpose to support and campaign for Sir George Allen to become the Secretary General of the Pan American Health Organization. And Mr. Speaker, if I had more time here and I wasn't looking at the clock, I could give you example after example. I could give you the examples in education, the seamless continuity between Erskine Sandiford and Louis Tull and Billy Miller and Cyril Walker and Keith Simmons and myself and Cappy Greenwich and Reginald Farley and Ronald Jones. You know what the point I'm making is, sir? That there are certain things that make this country exceptional. And I speak as much for the members of Parliament today because I'm conscious that most of them have not served as long as I have in this chamber and in the other place. But I want them to retain the memory. And more than the memory, I want them, when this party ever goes into opposition again, to remember that the hunger for power must never exceed the absolute necessity for patriotism that is designed to ensure the stability of this nation and its people. Now I start here because I feel that the country has not benefited fully from the total approach that we would have liked. But that has not stopped us. And I'm happy to report that every major agency and entity within the economic and social structures of this nation have generally been meeting with us in the context of the social partnership, the expanded social partnership, I should say, with the Social Justice Committee, and then the other individual things. And I want to thank the former Attorneys General and Chief Justices of the country. We met 3 weeks ago, or 4 weeks ago, I can't remember the exact date. I thank the Honourable Adriel Brathwaite. I thank the Honourable Sir David Simmons. I thank the Honourable Sir Marston Gibson. I thank the Honourable Sir Patterson Cheltenham. I thank the former Commissioner of Police, Mr. Tyrone Griffith. I thank Sir Elliot Motley, who, as a former Court of Appeal judge in the Northern Caribbean, also would have come. And I think that was it. And we have every intention of meeting where possible with the former, and of course Mr. Dotton, but Mr. Dotton, Darwin Dotton, is head of the Anti-Corruption, Anti-Terrorism Agency. The point that I'm making to you, sir, is that this government has spared no effort in trying to meet with as many people as possible. And the Honourable Attorney General has been fair and honest, and as to the allegation about the Barbados Bar Association, let us be clear. The Barbados Bar Association has a representative on the Advisory Council on Citizenship, Citizen Security, along with Mr. Michael Lashley, who sits in his own deliberate right, along with other lawyers who represent, I think, the Barbados Workers Union, but who are familiar with criminal law. And they constituted a subcommittee that were the first persons from whom we would have received the comments to the draft bill that the Honourable Attorney General has here. I still do believe, and I apologize publicly, that they should have received separately as an association the bill itself, rather than just relying on their criminal law persons. But effectively, Mr. Marty Garnes, I believe, is the chair of their criminal law committee of the Bar Association. So, while it perhaps could have been done differently, there is no substantive loss in any major way because it in fact went to the persons who carry that role, but in a different committee. Now, what is significant to me, sir, is what was significant to me in June of 2018. That when we started to do our canvass of all of the institutions in the country, that almost 80% of what is being recommended is the subject of absolute agreement. And then the other 20% basically not even so much opposition, but invariably tweaking of the mechanics of implementation or the protections that need to be put in place for the other initiatives to which people speak. And separate from the bills that are before this Honourable Chamber today, I will reflect on some of what that is, because this country will and must fight to keep it safe. And the notion, Mr. Speaker, that 200 people are going to hold Barbados to ransom will not be accepted by this government, and from my consultations over the last few months, by the majority of right-thinking people in this country who especially want to step up to the plate and want to work together, recognizing that in many instances we are fighting battles that should have been fought decades ago, that we have come to the dance late, as the Honourable Attorney General said, on too many matters. And because of the sense of wanting to carry as many people as possible and recognizing that we have a strong minority of voices that are very strong, decade after decade after decade, initiatives that should have been carried forward by this nation were put on the back burner in the hope of being able to achieve unanimity. Mr. Speaker, I would have loved unanimity on these issues too. But in the absence of unanimity, one must still govern. And this government shall govern. And this government shall not leave the people of this country exposed to the ravages that are being imposed on it by a handful of people who seem not to care about their own families, their own lives, and definitely not about the rest of the community and the country in which they live. Mr. Speaker, on that second occasion when we confronted a national crisis, the then Minister of Health led from in front and reminded us that there shall be no surrender and no retreat. I can find no better call to action than to repeat those words that guided us well during that last crisis. Mr. Speaker, with respect to our fight against those who would want to destabilize this nation, we say there shall be no surrender and no retreat. And Mr. Speaker, our battle has to be divided in two different camps. There is the fight to strengthen law enforcement, effectively to catch crime where it occurs, to avert crime where possible, to maintain peace and order. And on the other hand, there is the battle for crime prevention, understanding the sociological causes, putting in place things that will build social capital, recognizing that guns don't kill people, but people kill people, and hurt people, and that people don't only need a second chance, sometimes they need a first chance. And that if we can begin to understand that most people are crying out, as the Chief Education Officer said earlier this week, a hunger, in some instances, a hunger for affection, and in some instances, a hunger for food and sustenance. And this is a country where this country at emancipation received the worst of the worst circumstances when the Located Laborers Act was put in place that effectively continued slavery for another century. But we found ways as a people to be resilient and to fight off battles that others would never have been able to treat to. And I say that because it is in that building of resilience and building of common purpose that families were able not to die from starvation, that people were able to ensure that children still had a home to be raised in, because there was a share pot mentality, there was a shared purpose. And Mr. Speaker, that crime prevention framework must culturally seek to bring back a resilient, caring, empathetic people who also would recognize that in every generation there will be sociopaths. There will be people who go beyond the pale, but they must not be allowed to do so at the risk of the stability of the community or the country. So we don't expect that we can do what has never been achieved in the history of mankind, but we do expect that we can contain and minimize. Now the difficulty is that the country finds a confluence of things happening at the same time that we have to address. A propensity for violence, an inability to resolve conflict in agreeable ways, access to technology that is lethal. The same technology that conquered Africa, allowed Europe to conquer Africa. Handful of Europeans conquer as a result of gunpowder. Without gunpowder, they would not have won. And the same gunpowder in bullets, and worse still, in automatic weapons, creates an imbalance in power that effectively gives the ability of a few to torment and terrorize the majority. 3, an increasing prevalence of substance abuse yet again. And I speak now from history again. When I became a young attorney at law at the age of 21, just the other day, in 1988, this country was facing a problem with crack. You remember? And that's how the word paro came about. And we had already seen an increasing use of marijuana, which started among the expat community in the early 70s and white Bajans, moved its way to professional Bajans, and by the mid-80s was in every community across the country. And the attitude to it has equally also changed with respect to the use of marijuana. But the prevalence, I knew about heroin cases when I was practicing in the early 90s. And then we went through a period of time where you didn't really hear much about crack, you didn't hear much about heroin. Admittedly, we saw an expanded utilization of marijuana. And in those early days, late school days and early days as a lawyer, you also heard more then about amphetamines and other synthetic drugs. We have now seen a resurrection of some of those other drugs. And I've asked the Minister of Home Affairs to ensure that the National Council of Substance Abuse goes from community to community to community, as it did, ensuring and showing the social partnership what is out there. And the member for Christchurch West Central is passionate about this because in his substantive profession as a pharmacist, he fully understands and appreciates the danger of what he describes as polydrug use, where a person will move and take at the same time what they call mollies, while at the same time drinking some lean. And what is lean? And why is it called lean? Lean is called, I'm told, because persons would walk literally at an angle leaning after they take it in the States coming out. And why is it so dangerous and prevalent? Because your child can go in the supermarket and buy a Sprite, Jolly Ranchers, and when he go home and you got cough syrup in the cupboard, then you begin to have a problem in terms of how they mix it. In addition to that, you have fentanyl. And you heard President Trump at the beginning of his term state much of what he was doing, even with tariffs, on the whole issue of the illegal trade in fentanyl and the extent to which it is creating havoc across cities in the United States of America, and more to the point, amidst and amongst families. And the danger is that the manner in which many of these things can be smuggled is relatively easier than moving 100 kilos of marijuana or 100 kilos of cocaine, which by virtue of the size and density is difficult to move, but with respect to the fentanyl and the amphetamines and the other things, they are so small and they look no different from the majority of pharmaceuticals that persons carry, from blood pressure medication right back through to headache tablets, etc. And therefore, that is the challenge. And when you get the fifth area coming in, which is mental health challenges, you are beginning to see the confluence for a perfect storm. I have said over and over that this region bears a heavy price for the Second Amendment rights of the United States of America. And the prevalence of guns legally there has found its way throughout this region to the point where the Caribbean and Central America, not Barbados, and it's nothing that we gloat on, but the Caribbean and Central America have the highest per capita incidence of murder in the world. Small countries struggling to bring development to their people since independence. and a handful of people with access to automatic weapons, putting at risk the stability and putting at loss lives and employment. There can be no doubt in anyone's mind about the resolute nature of this government in addressing both limbs, the law enforcement and the crime prevention aspect of what we are doing. And Mr. Speaker, you will forgive me if on this Friday evening I take my time, because this is at the core of this country's future stability and prosperity. And that is why I so regret that the honourable member did not find the courage, the honourable leader of the opposition, to stand up and be in a position to find common purpose with the people and government of this nation with respect to this fight. I know that they have, and let me be very clear, they have been offered on many an occasion. And today, he chose to do that which even he should be ashamed of, given his recent comments in a press conference on the 16th of June of this year. But the problem is that this is crop over week. And I may well now have to ask myself whether he ever jumped a day in his life, or is today his first day in political gyrations, moving from side to side to side to side. Others say he might get jumped. But let me remind you in this chamber of his words on the 16th of June 2025. We therefore, as a party, would want to support, this is in relation to the wireless interception legislation. We therefore, as a party, would want to support such a measure by the police, because this is about death now. This is not benediction. This is not merely about people losing their property. This is about people losing their lives, and this society must be protected against crime. Now, he did talk about political concerns, but he was very clear in his support for the need for it. And in fact, he said that if the police are on to something, and quite often the police are on to things, I say, let the police continue their work. Now, this is the same man who spoke, this is the same honourable member who spoke to me and agreed that he would go on the Advisory Council for Citizen Security. And then, 2 days later, when the Cabinet Secretary was calling him, he told the Cabinet Secretary that he would be late to the meeting. So how can you deny something when you told the Cabinet Secretary you would be late to the meeting because you had the thing? When he first spoke to me, he told me he was going to consult with his people. Told the Cab Sec he would be late for the meeting. But then this was the same honourable member who told me behind the chair of the Speaker that he would also meet with me and the Minister of Education and the Chief Education Officer and the member for St. James South and St. Philip West were downstairs waiting in the room, and the member for St. James North, he was then a senator, were all downstairs waiting in the inner dining room while we were waiting for the same leader of the opposition who committed to the meeting and bringing all of his members to the meeting for a lunch that was catered for them to the meeting. They had the lunch, but they didn't come to the meeting. This is the same honorable gentleman. I have been stung once. I have been stung twice. Today is the third time. It's true that he did not speak to us directly on this. He spoke to the country on June 16th. Now, if the honorable member had said in here that I don't like this provision for the monitoring committee, and I feel that it is not sufficient for that committee to be appointed by political persons in the form of a minister. Can we meet and change this? I would have said, let us do so. And the part of me that now has to go beyond duty and to stand up not for me or the Labour Party, but for Barbados, is going to stand on this floor of the House today and say that we will amend this bill in this Parliament to ensure that those 3 persons on the monitoring committee are appointed by the President of Barbados without consultation with either the Prime Minister or the Leader of the Opposition, so that there is no risk of political interference, as he would suggest to the country. Now, Mr. Speaker, if he did not speak and run, other people is hit and run, he is speak and run. If he did not speak and run, and I don't know if he went to call 911 or what, but I know he ran. And I don't know if that meant that somebody get licked. No. I don't talk about rats getting licked. No. I take charge. I don't talk about rats getting licked. No, I can take charge. Look, it's crop over week, so we laugh. As Chalky says, Mighty Chalk does said, if you don't learn to laugh, you go mad and write your epitaph. Classic song that Chalk does wrote many years ago. But the point I'm making is this. I don't expect us to agree on everything. Everybody in the cabinet does not agree on everything. But we work to find common purpose and we bring it out. The social partnership does not agree on everything. Labor, capital, government. But we find a way to talk it out. I find it amazing that not only did he not seek to have that constructive approach, and I have committed this government to amending this bill before it leaves this chamber today. But my point is this. I would have rather to have been in a position to have read their Commission on Crime report, but the thing was launched when I was at the Emancipation Walk last week, Friday. They were having a press conference launching this Commission's report. I left Bussa. I asked everybody, I said, I want a copy of the report. Nobody can give it to me. I wake up the Saturday morning before my fete. I said, I want a copy of the report. Nobody can give it. I said, how you mean Saturday? I said, all right, it's crop over weekend. Let me keep quiet till Tuesday. Tuesday, I asked for a copy of the report, can't get it, nobody ain't got it. Wednesday at the social partnership, I asked for a copy of the report, nobody ain't got it. Thursday at cabinet, the others tell me there's a summary somewhere floating about, but we still can't get the original report. Mr. Speaker, I have come here today to serve notice that my weekend reading this weekend is their report. Because if it is that the only way this country can get a national approach is by allowing him in his petulance and immaturity to do it on his own, then we recognize his petulance, we recognize his immaturity, but we will stay focused on the immediate concern, which is bringing national unity to the fight against crime, such that there is no surrender and no retreat. And I will read it. And on Tuesday, if he is willing, we can meet and discuss it. Or any other day for that matter, because he might tell me that I choose the day and it ain't convenient. So let him choose the day. But the point I'm making is this: where there are things that are already agreed upon, increased police presence. What is this bill here today to deal with? To turn special constables who have had more than 3 years' notice into police constables. They know the job. They must be given the opportunity for promotion. It also gives the Commissioner of Police the ability to increase presence on the ground by being able to also give powers of arrest to other people, but in particular, the members of the Barbados Defence Force. That is increased police presence. If there are other things that we agree from their report and our consultations with the social partnership, the expanded social partnership, and the program that the Honourable Attorney General and the Honourable Member for St. Michael South, the Minister of People Empowerment, and I want to thank the member for the City of Bridgetown for the previous work that he did in building the platform that we know to be a credible platform for crime prevention. That I say to you that this government is not caught up in itself, is not peeping up under itself, is not frightened of itself, is not frightened of the people of this nation. And that we have said we do not believe we're omnipotent, we do not believe we're omniscient, and wherever good ideas come from, the government will meet with the citizens and implement those good ideas because we believe they are in the interest of the nation. So let us be very, very clear on this. We will review it. I said earlier that I believe that Ms. De Pisa is a serious person. I have known her to put the country's interests at heart, and therefore any matter which she was responsible for in terms of chairmanship will command my time and my respect. And I give the country this assurance. But let us go further. What is before us, and the Honourable Attorney General did well this morning in articulating the issues for us and teeing up everyone. And this Needham's Point Declaration, which he laid as a document of this House that was passed on the 20th of October 2023, is the result of a major consultation by the Caribbean Court of Justice Academy for Law in its 7th Biennial Law Conference, Criminal Justice Reform in the Caribbean, Achieving a Modern Criminal Justice System. Mr. Speaker, this government philosophically has determined that its time in office is about reform and transformation. That is why we took a 19th century and early 20th century juvenile legislation, suite of legislation, and replaced it with a modern child protection and a modern child justice law. That is why we are in the middle of the member for St. Michael South bringing forward a new institutional framework for welfare in this country and for family development that is not based on a Victorian 19th century approach to how you treat to people with the poor laws and all of the archaic systems that would have literally seen bodies but not seen people and souls. That is why we are equally engaging in the reform of our criminal justice system. Anybody who is a lawyer knows that if you were so stupid to go and buy the new Archbold editions, you would have wasted your money, because the new Archbold editions would have reflected modern statute in the UK At a time when in Barbados, most of what we were dealing with was a combination of some statute and a lot of common law. That's why I laugh. I hear all of this about stand your ground legislation and all of this. How many people know that it is the common law of this country that if someone trespasses on their property after 6 o'clock in the evening, before 6 o'clock in the morning, that they can defend their property and their lives? That's the common law. You don't need to pass statute to replace the common law. You can do it if you want to have greater clarity. But the law of the land is made up of the Constitution at its apex, statutes under the Constitution, and subsidiary legislation under statute. And within the context of that hierarchy, there is an outside child, for want of a better phrase, that sits below the Constitution and virtually alongside or just below, depending of statute law. And that's the common law. So that where the statute is silent, the common law will prevail. So that, I'm not going into a tutorial, but it is important to know, because we have not just arrived at this spot. And for whatever purposes, you know, you come to a job for such a time as this to say, well, my preparation was in the practice of criminal law, in the engagement of law enforcement. I served as an attorney general, and therefore was equally involved with the establishment of the Commission on Law and Order, which was another broad-based commission in the country chaired by the preeminent Sir Roy Marshall, and having persons such as Brigadier Lewis and the former Governor General, Sir Elliot Belgrave, and Mr. Harold Hoyt, Mr. Andrew Pilgrim. I can go on and on. A distinguished set of Barbadians whose report is as valid today as it was 20 years ago. So that I want to give the country the assurance, Mr. Speaker, that I do not rest as long as Barbados is not safe. This government as well will not rest. And I want to thank the police. There's work that we have to do, but there is much that they have done already to avoid calamity and to avert crisis. It's not everything you can speak about, but suffice it to say that I didn't come in here by accident in 2024 March and ask that the terms and conditions of detectives be treated as a special case, such that they be allowed to have the allowances so that persons would not find themselves leaving detectives' work and going back into plain clothes, because under the flexibility allowances and the other systems, they could earn far more than a detective could earn. We would not have come back in here this year and moved the position for those 47 special constables, I think, or how many ever it is, to move to police constables, but to go the additional distance and agree to another 60 special constables in this year of our Lord 2025. And the training, I believe, started in the last week or so, and will take about 8 weeks for those additional 60 special constables that will come on. As we speak, the police are also reviewing to remove and to civilianize certain posts that, quite frankly, do not need police officers. You heard the Honourable Attorney General, you heard the Honourable Minister of Home Affairs with respect to the issue of criteria for entry into the police service. And a modern Barbados cannot be curtailed by colonial approaches and colonial attitudes. And to that extent, therefore, this is but the first step but we recognize that there will be further modifications with respect to professional development of police and access to the force and the terms and conditions of the service, as we go forward. Similarly, we have made the decision, you've heard, with the extension of the power of arrest to the soldiers, but this country, certainly for the 34 years that I have been a member of this parliament, it's so long, 34 years, we have seen joint proclamations for the use of the police and the Barbados Defence Force in every single year that I have been a member of this parliament. And that is done by cabinet and previously the Governor General, now the President. In addition to that, the matter of the intercept of communication legislation, let me go back to the beginning again. This matter has its genesis, to the best of my knowledge, to then Prime Minister Sandiford and then Attorney General Sir Maurice King. These are not matters that we would have expected to have to speak to in a fulsome way. But the attitude of the Leader of the Opposition means that there are things that we have to put in context. Because this notion that this intercept legislation is being introduced to spy on political partisans is the biggest amount of foolishness that I have heard. And that is why even he, when he spoke on the 16th of June, talked about the need for the approval of the request by a judge. That's what this legislation does. And that is why the Caribbean Court of Justice Academy could recommend at number 18 and number 6 and number 11 and number 13 of its declaration, words that support the introduction of almost every piece of legislation before this parliament today. Let me read it again. Paragraph 6, that laws be enacted to provide for greater use of forensic, scientific, digital, and expert witness evidence, including the use of modern evidence gathering techniques such as interception of communications, digital recording of confessions and interviews, and DNA testing. This is preferable to prosecutions based solely on admissions and confessions. Now, this legislation goes further than most of the others in the region, in that it now allows us to treat to the substance of the intercept, not just as intel to help you investigate the case and to solve the case, but to treat it, Mr. Speaker, as evidence. And why is this important? In a country and in a region where more and more people are shying away from coming forward to give evidence in courts of law, people are walking that otherwise should be convicted if the jury were given the opportunity. And you would know, sir, that there are a number of people who get away lucky. Because the witness said, I ain't getting the evidence no more. I ain't coming forward no more. Nobody ain't gonna kill me. Let's talk real. But if we have the intel, we will be in a position, if allowed to admit it into evidence, the cross-examiner, who the person defending the defendant will cross-examine on it. The prosecution will address it, and the judge and the jury will speak to it, and in the case of a jury, decide. In the case of a judge-alone trial, the judge will decide. And these are the things that we want to keep this country safe. I haven't read their document, but someone told me that they have a chapter in there called Justice Delayed. This is the government when he sat on the backbench that brought amendments to be able to deal with delayed judgments and delayed actions. Mr. Speaker, you will recall. But this is also the government that increased the number of judges from 2 to 8 and doubled the number of prosecutors from about 8 to 16 to make sure that we can bring cases shorter. Now, we are satisfied that that has not been sufficient, and therefore we are putting systems in place to help the police put together the case files so that there is no delay between, as you would know, Mr. Speaker, practicing in the courts yourself, the charging of a person and the commencement of the hearings, so that you don't get 6 months, a year, 18 months, 2 years passing, and the cases start yet. That cannot continue in this country anymore. And the proof of the pudding has been in the government putting in place increased budgetary support, increased judges, increased prosecutors, addressing the issue of the forensics lab and fixing it, because we came to office without it working, and putting in place what we committed to on page 26 of the Covenant of Hope, that the first claim on public expenditure is national security and law and order. Now, I have to be brutally frank. We are not where we want to be with those timelines, with those cases, and we have spoken to all concerned to see what can be done to close the gap to ensure that those cases can start. And let's take a firearms case. That's why there's a danger, because I know the law too well. How many witnesses you got in a firearms case? Think about it. The body that find the gun. If the accused person make any admission, the person to whom he spoke, or she spoke, and the ballistics expert. 3 witnesses? And you can tell me that you can't do that case in 3 months' time? That all firearms cases in this country cannot be done in 3 months' time? 4 months' time? 6 months at the outer limit? Let's take the average murder case. The complexity comes not in the compiling of the statements. There is no reason why most murder cases cannot be done within 6 to 9 months, Mr. Speaker, sir. You know. You know. And most people now do not do a preliminary inquiry so that you get the statements by paper committal. And then let's go further, Mr. Speaker. If it is 5, 6, 7 accused, I can understand that you will need time for a long trial, but you don't need a long time to start the trial, because the complexity really comes when the case is being heard through the multiple cross-examinations and the multiple applications to the court and the multiple addresses to the court. But to get to the start, the compilation of the evidence, in most instances, the police know why they've charged somebody, and they may be waiting some confirmatory evidence that is forensic. Other than that, or ballistic, other than that, most of the statements are already available to them at the time at which they charge the person. And if not immediately available, can be made immediately available thereafter in 90% of the cases. So I'm satisfied, sir, that this matter is one that the government and the opposition and the people of Barbados can find common purpose on. And that's my point. That's my point. And while we don't expect unanimity on everything, we expect you to get up and come to the table and let us have the conversation. With respect to the wireless intercept, as I said, we will change that monitoring committee to be appointed by the president. But all of the other safeguards are in this legislation. And to that extent, If I were to tell this country the calamities that we have avoided over the last 20 years to my certain knowledge, there would be no more discussion, you know. But as Minister of National Security, there are certain things that you have to allow me and to trust the government to be able to deal with as national security, and the police as operations to deal with respect to law enforcement. And why do I say so, sir? Do you expect in playing dominoes that you can pull a hand and skin it up? How you pull a hand in dominoes and skin it up? So are you going to pull a hand and skin up the whole strategy that the police have, or the defense force have, or the financial investigations unit has, or the cybercrime people have, in order to catch the people that they want? You don't do that. And nobody outside, from shop to supermarket, from church to school, will expect anybody to diminish their safety and security by doing that. I want to give this Honourable House the assurance. The tweaking to the firearm legislation is necessary, and we will continue to tweak as necessary. Because when loopholes are found or being exploited, then it is our role to close them. We said we were not omnipotent nor omniscient. And the irony is, it's not the government of Barbados alone, it's almost every other country. The Bail Act. We chose last year to bring a South African Bail Act here. And quite frankly, it is now beginning to pay its dividends. Because if persons are going to be a threat to common public spaces and society, we must be allowed to protect innocent people in this country. And if people are looking for you and looking to shoot you wherever you turn up, then at some point the police can say that this person who is on bail and who is supposed to be presenting themselves once a week or twice a week has now become a threat to public safety, because every time he's in a public space, somebody wants to shoot him. Man on bail, you know. The legislation now says that the police have the power to revoke bail and not just deny bail. So that, let us be clear as to what the role of government is. We are the lawmakers. We have to bring the legislation that strengthens the hands from the police to the courts, to the forensic people, to the victims, to the society as a whole. We are the purse string holders. And there has not been a single occasion in 7 years that the police of this country have asked for anything at all in terms of their budgetary expenditure, and it has been refused. In fact, Mr. Speaker, I would challenge the Attorney General to go and do his numbers such that when we're in a debate again, that either he or the member for Christchurch East Central can get up and show the extent between which the Ministry of National Security under my ministry and the Ministry of the Office of Attorney General responsible for the police have shown where we have supported them fully institutionally and individually as officers. And in fact, we have extended the POLTA, the travel allowance, to the sergeants. We have improved their terms and conditions. And let me be clear, sir. Sometimes there is an unacceptable lag between what we announce and what is implemented, particularly in large organizations like the police and the hospital, and in education, where there are thousands of people that they're dealing with in terms of processing. And that is why we are so adamant on getting the digitization processes through for these large institutions, especially now that we have a little more freedom fiscally to ensure that they can benefit and they can process their work in a more efficient manner so that there will not be that lag that we're talking about between announcement and payment, as has happened regrettably with respect to the police. I have said to the Honourable Attorney General, please make sure that the police are paid for crop over by the end of August. The issue is not money. The issue can only be processing. So let us put the systems in place at the police to make sure that they receive their funds all between now and the end of August. And similarly for Carifesta, that by the end of September, that they receive their funds there. And that's the kind of standards that I want us to become accustomed to. I'm not going to stand and defend the indefensible. If there are time lags that should not be there, let us get rid of them. Now, Mr. Speaker, in addition to that, this government, like the other heads of government, is seriously considering making certain domestic acts in public places acts of domestic terrorism. If you go on a Sunday morning in a gas station and start to spray bullets in that public space, you have not gone to commit the crime of murder alone. You have perpetrated an act of domestic terrorism, because beyond the person who may be injured or dies is the inculcation of fear in the society. And that is what terrorism by definition is intended to elicit. If you come in Bridgetown, on Robert Street, or St. Michael's Road, and you pull a gun because you see a man that you got a beef with and that you're looking for him, and you are prepared to do that, then there ought to be a crime for domestic terrorism. We have a crime for international terrorism. There has to be a crime for domestic terrorism. And homegrown terrorism in different countries is different things. The Oklahoma bombing in the States was a form of domestic terrorism. I say to you, sir, that this House hopefully will receive such a bill, as well as other Caribbean countries, because we have to call it what it is and to go after it, because there shall be no surrender and no retreat. Mr. Speaker, in addition to that, the government will continue to put serious support for in situ training. You would have noticed 2 senior members of the police service on training for 6 months this year in the United Kingdom. I am told that another 2 go at the end of this year for another 6 months. But even if we were to send 2 and 4 and 2 and 4, we have 1,300 officers roughly in the service. And therefore, the government took the decision, and when I met with Sir Keir Starmer and the United Kingdom government earlier this year, I reinforced that we would want the ability to do in situ training on the spot training in Barbados, so that the widest possible number of persons who need it can receive training in modern policing, modern forensics, modern ballistics, so that we can literally up our game and continue to be ahead of those who would want to destabilize this country. As it relates to the Juries Act, there can be no more anachronistic situation than we've inherited there. And the member for Christchurch East appropriately described it, as did the Honourable Attorney General. You cannot have that continued waste of time. If we have the evidence that can allow us to do the rape, the murder, and the burglary all at once, then do it as one case rather than having to hold separate cases, because the requirements for who constitutes a jury by law are different for the offense of murder, where it needs 12, for the other offenses invariably where 9 is usually the number. So that this allows us to be smart and efficient rather than being a victim of inefficiency. We spoke earlier of the witness anonymity problems with witnesses, and hence the need now for witness anonymity is absolutely essential. And we live in a world where, look, how many Zoom calls you do a day? At least 3 or 4. We don't be in the same building. We don't sometimes be in the same country. We don't sometimes be in the same hemisphere. The only one we haven't been able to do is one with a man on Mars. But we can do with on Earth, we can reach everybody. So the modern legal system has to catch up with the rest of where the society is. And the society allows for that kind of instantaneous communication. And similarly, we should be able to not have just audiovisual evidence, but we must be able to protect the identity of witnesses where necessary to ensure that there is not vengeance exercised upon them and persons seek to take matters into their own hands to prevent them from being able to give evidence. Mr. Speaker, you heard me say that we had a number of consultations with the social partnership, and you're going to begin to see the consequences of that, and you're also going to begin to see us roll out consultations at the community and parish level in order to be able to have the kind of commitment for Barbadians who is stepping up. Who is stepping up to help to ensure that we can win this battle to keep our country safe. Bottom line is, we all know that when we were growing up, there were far more community groups, social groups, sporting groups than exist perhaps now. We all know that our children have found comfort in the other addiction that I should have referred to in the 5. It probably should have been 6 factors finding confluence. And the 6th factor finding confluence, regrettably, is addiction to social media and technology. And we are at risk, Mr. Speaker. The member, I believe, for St. James North will address this chamber with a ministerial statement on Tuesday on the educational transformation. But we are at risk of having generations and current one and future ones not developing the capacity to concentrate, discern, and analyze because of this addiction to short form media. 30 seconds, 60 seconds, 2 minutes, 3 minutes. And anything beyond that, not interested. And then when you combine with that the capacity of AI to summarize almost any document in seconds, you begin to recognize that we have to find countermeasures to maintain people's capacity to concentrate. But first and foremost, we also have to let them look in the mirror and love who they see. The issue of self-confidence and self-esteem is utterly and absolutely critical. There are too many people I know, I don't need to know about now, there are too many people that I have defended in my life, in my career as a criminal lawyer, who when you start to talk with them, you would know, Mr. Speaker, they're in the big bad bogies, they're looking for attention. What the Chief Education Officer said, they're hungry for affection, hungry for empathy, want somebody just to stroke them and say, it's okay. Want somebody to engage with them and listen to them even if you don't say nothing. And we have to find a way in our school system, but equally in our communities for those who have left school, to be able to bolster self-esteem and self-confidence, to strengthen literacy, particularly where persons left school without the ability to read properly. And the government is going to commit to a number of things on Tuesday in the school system that are intended to be able to help us with the building of social capital and the removal of a number of the challenges by trying to reinforce how we prepare our children, what they're required to do, how long they're required to do it, so that if we don't get all, we can certainly minimize the ones who are at risk of falling off the edge, proverbially. In our conversations, we discuss the issue of parental accountability and liability. Mr. Speaker, let me be blunt, and I said this a few months ago. The government cannot go in anybody's house and tell their child, come and go to Sunday school now. The government cannot go in anybody's house and ask The little girl or boy, where you get that chain from? I didn't give it to you. Your grandmother didn't give it to you. The government cannot go in the house anymore either and tell you not to feed the child only corn kernels and macaroni pie, but no vegetables, nowhere to be seen. I am making the simple point that the government, yes, must pass legislation. The government must help fund. The government must help lead. But there are certain basic things that the government cannot replace parents for. The most we can do is to create a system to find other persons who are prepared to play that role in loco parentis, in the place of the parent. That's why we have fostering. That's why we have the child care board and others to support. But the government cannot replace good, solid parenting. And therefore, the country, I believe, is ad idem on the need for greater parental education, greater parental empowerment, but equally holding parents accountable ultimately for their behavior. Punishment will not ever be the first option of this government. The first option is always training and boosting capacity and giving people an opportunity to learn. That's why the Ministry of People Empowerment now has parental coaches and life coaches in the community. Because we accept that in the same way the public health nurses used to go around, certainly when I was a child, and make sure that people were taught how to mix the milk and how to deal and how to burp the child and how to deal if the child got colic. All of those things, we are going to have to go back out there in communities and help parents, particularly where children are having children and don't have the support of a village to raise those children, to go in there and help them understand. And in some instances, there may be postpartum depression. A woman got 2 children already, 5 years old, 7 years old. The 3rd child come now and she got this depression and nobody in understanding what really going on with the dynamics of these other children in the house and the mother. We need and can do better. And that is why the government also introduced the One Family Initiative. I've said over and over, if we accept that 1 out of every 5 families is below the poverty line, the corollary of that is that 4 out of every 5 is above. And this is a plan and a program that requires not just the government, not just the private sector, not just the labor movement, not just the churches or the mosque or the temples, not just the NGOs, but all of the above, plus the individual households and the individual parents and the individual godparents and the individual grandparents and the individual neighbors. Are we getting the point? That it requires the majority of Barbados. And this country, because it is exceptional, this country, because we have risen to challenges before that have daunted others, has the capacity to rise to the occasion and for us to take care of each other. If every one of us adopts a family who can do so, you buy 2 extra chickens when the week comes, or you buy some sanitary items, or you buy some vegetables. When you carry it to the house as opposed to a food bank, you then have the ability to interact with the family. You have the ability to see that the little boy playing football but ain't got no shoes. And then you say, man, don't worry about that. I can buy him a pair of football shoes the next time I come. He can get next week. Or you see that the little girl needs glasses and nobody has taken her to see and to the optometrist to get her eyes checked. And you say, man, I'm going to call my optometrist and make arrangements for her to go and see him next week. Because that human interaction, I know my people. I know Bajans. And Bajans like to protect people. They like to fight against unfairness and injustice. And if they see somebody suffering, most people in this country will go inside and get whatever little they got and share it, because that is how we know we got through centuries. And I say to us, if I have one complaint against the Ministry of People Empowerment, it is that it does not work aggressively enough to advertise sufficiently, strongly, that we are on to our second 1,000 instead of being on our first 1,000. And I say so because I know what this country can do when we band together. This country is exceptional. But we must do it together. I said the Minister of Education will announce a number of measures pertaining to school. The Minister of Transport and Public Works also will have the comments from the Barbados private sector and the labor movement and the Evangelical Association and the Christian Council as it relates to GPSs and cameras on public service vehicles. And you may ask why once again, but it was 2 years ago that at 8 o'clock in the morning at Eagle Hall Crossroad, a man shot through a public service vehicle. It was year before that Van Wyck captured the imagination of the Barbadian public in his bravery. So that we now know that these are not academic things we are talking about. These are tools. And if the criminals have access to the same technology, how are you going to stop the government and the police and the others from using the technology to be able to deal with the criminals? Mr. Speaker, that could only come from somebody who don't want crime fight in this country. Here I am in that foolishness. Anybody who is interested in making Barbados safe will use all legitimate tools in alignment with the Constitution to do what we have to do. Mr. Speaker, on the matter of truth verification testing, the government has spent what? The Honourable Attorney General spent about 2 years in consultations with the labor movement and the various departments who have access to the airport and the seaport, as well as the private sector, because the government has made a decision that if you want access to the airport or the seaport to work inconsistently, you are going to have to be subject periodically to truth verification testing. Fancy words for lie detector tests. The first thing one person asked us in the social partnership on Wednesday is who can guard the guards? Do you remember that? And it wasn't a member of government who said it. But the government is ever aware that this notion of who will guard the guards is continuing to be a major issue, not just in Barbados, but across the world. Now, we believe that the majority of people are good, but we do in every profession, in every sphere of life, have persons who sometimes may stray from the center and start to get involved in things that they should not get involved in. And to that extent, therefore, Mr. Speaker, we believe that the truth verification testing is absolutely critical. People ask where the guns have come from. The guns that came in when the last Commissioner of Police and others said that they were coming through the port. Remember this in 2016 or 2017. Those guns have not rusted and gone in or degenerated like compost. They're still out there. And the real problem is not only the guns, but is the ammunition. Because a gun without ammunition cannot propel anything. And therefore, it's a combination of the serious law enforcement effort to be able to constrain and control that. Now, Mr. Speaker, the Honourable Attorney General and the Minister for People Empowerment would have also done a study tour with members of the police with respect to how we start to deal with the issue of gangs and guns again, and have been working closely, I think we mentioned it in the estimates, with CRED, I believe is the name of the entity, that is led by the former Secretary of Education of the United States of America, Mr. Arne Duncan, who was President Obama's Secretary of Education. And this is supported by a number of NGOs for funding, which allows them to be able to deal, and I will let them at a future occasion, since they were the ones going on the study tour, be able to ensure that we find ways, including immediate engagement, to be able to bring people from that pathway of guns and gangs and violence to one that brings them back into mainstream society, recognizing the error of their ways. It is not simple, because you're also dealing with societies that have not yet perfected how it treats to the marginalized, and the notion that we are dealing with a generation that is different and that typically does not trust, that believes that hypocrisy is a large part of the problem of the institutions with which they deal with. And in fairness, Reverend Eligius Joseph would have presented to the social partnership in a way that allows us to begin to understand that we need to be able to rebuild trust in every institution, from the church to the police to the state to the private sector, employers to the people with whom they work. Let me put it as basic as this. How many times have you heard people say government name? Well, I didn't know what was a government name until I understood the slang of the current generation. We know about Christian names. We know about surnames. But they have now created an alternative, a government name. Because most people are known by their alias and not by their government name. By the same token, there are ways in which people create their own alternatives that we have to be aware of, and to see how our institutions have to adapt in order to be able to include people who feel marginalized and who will not participate in mainstream society to be able to get so. Why is this so important, Mr. Speaker? Barbados is too small. There is nowhere to run. There is nowhere to hide. And if we don't confront this issue and deal with it frontally, we will pay the price. I am old enough to know how every decade, in every decade we have kicked things to the next decade. Remember, for St. John, found the paper that I wrote as minister along with Mr. Richard Carter 30 years ago as Minister of Youth Affairs for the establishment of a National Youth Service. It was kicked to the next decade. In fairness, I believe at some point the last administration, Democratic Labour Party administration, also flirted with it but never brought it fully to the country. It was left unattended. The behavior of PSVs has been kicked from decade to decade to decade to decade to the point now where it is this government trying to bring order to what has really been an unruly and an uncontrollable situation with respect to how people behave on the roads and the extent to which road rage and road rudeness have become common. Littering, recycling, kicked down from decade to decade to decade. Behavior. People started to wake up yesterday, last month, last year. The country needs for us to recognize that we cannot complain about what we have if we are not prepared to do something to change it. Educational transformation, education reform, the children left on the side. Mr. Speaker, it hurt me. I put a reading program in place as a Minister of Education. The member for St. Thomas can tell you. It was removed. And regrettably, it never came back in place until we've just committed to putting it back in place and started it 2 years ago, or 18 months, however long it was. And I say this because when you read the reports from the criminologists, you see common patterns. I am on record this year as saying that I do not believe that any child should be superannuated at 16 and sent out in the middle of a school year. And when I got the records, there were too many. But more importantly, there were a few instances of people at 15 and 14. Mr. Speaker, as Minister of Education, I brought the framework in here for the creation of the Edwin Nichols School. It was always intended only to be part one of a two-phase solution. And I've asked the social partnership again, the second part of that two-phase solution must be a residential facility that can take those children who are too much for the family to handle, either by the family's admission or by the requirement that the chief education officer working with the child care board go before a court and say, look, let us help this family stop this child from going down this particular place. In all of these instances, this government chooses empathy and training as a first measure. But do not get tied up, because if the empathy and the training do not work, then the law must be applied and enforcement will be followed. And we have been fair. And why? Because the majority of citizens of this country are law-abiding and deserve to live in an environment of peace. And I close this evening by saying, sir, that the commitment of this government seen simply today by the passage of these 5 bills, 5 separate pieces of legislation brought in short order. What is to come? The criminal procedure rules. What is to come? Other pieces of legislation. And we have asked for a review of the anti-gang legislation as well, because unless that creates new offenses and unless it has a high enough threshold, it does not advance us. And therefore, the Honourable Attorney General is doing his research as to where and how it has worked in the region and what new offenses are created that do not now exist at law, as you know, Mr. Speaker. Because the other thing is that we have not traditionally been good at the charging of what we know as the inchoate offenses, the accessories to a crime, the conspiracy, all of the things that previously would not have been there. So that, please, Barbados, know that this government will not rest until there is stability. We cannot promise the removal of all crime, even though we shall work towards it, because we know it is unrealistic. But we do believe that we can make substantial progress in making our communities safer. And I want to thank all of those young people who participated in the Prime Minister's Cup last year. And we made it clear, do not have any gun violence out there on the fields, because the very things that are bringing opportunity to your friends and family will stop if gun violence is out there. And you are therefore only hurting those who need help the most. And we had an incident-free Prime Minister's Cup over the course of the 3-4 months. I have no ability to look into the future, but I say simply to those involved again, if we did it once, we can do it twice. Let us make sure that we keep conflict and acts of violence away from these public spaces, because there are a few people who are waiting to say, you shouldn't hold it. I tell you, don't hold it. Don't trust them, young people. And Mr. Speaker, you have to be able to give people a chance. But if you play the fool, shut down and we look for something else to do. The rules are very clear. So we stay good. We continue with all of the events and opportunities. We step on the crease, umpire puts up the finger, and you're out. So I look forward to our being able to build out the social capital necessary to work with the law enforcement, to remind Barbadians that the police, even in the face of wireless intercept, the strongest evidence still is always human intelligence. And that the police are our friends. In the instances where things have happened that are untoward, they will account for that. But in everything, you may find 1 or 2 bad apples, but the majority of them are doing well and must be encouraged to continue doing well. The fact that in almost every instance, the police are able to find the people and charge the people has also been a good sign. But the remaining large part of the battle is not only law enforcement, it is in every household, every grandmother, every mother, every father, every grandfather, every brother, every sister. because guns don't walk on their own. They have to be hidden. They have to be moved. And if you see something, we say something in order to protect the people who you love. Because the way that karma works is that the persons who we least expect to be injured or to be victims end up being innocently affected because of foolishness and recklessness on the part of others, who then come the morning after and say, I didn't think, or I shoulda, or I coulda, or I woulda. Replace a shoulda, a woulda, a coulda by just simply doing right. And if you see wrong, say something and let us keep this country safe. I look forward to the majority of Barbadians stepping up to the plate, and I give you the assurance, we shall not rest, for there shall be no surrender and no retreat against this battle of crime in our society. I thank you.
Honourable Member for St. Joseph.
Mr. Speaker, I think that we've had the benefit of a fair and accurate statement of the government's position on all of these matters. We have gone through them in some detail. Yes, we've gone through them in some detail, and I believe, sir, that as with every important piece of legislation, we should encourage the public to go to Parliament's website, look at the legislation, and study it. And I'm confident, Mr. Speaker, that when they study it, whether they do it in small groups or whether they do it alone, whether they have a chat with a friend maybe who's a lawyer or a law student, they will begin to pare back the false layers or the falsities in the layers that the Leader of the Opposition presented to this chamber as his argument. It is bad enough, Mr. Speaker, that having spoken in support of the legislation, he now comes to this chamber to disavow it. But what is the biggest misfortune is the fact that he has sought to stir up distrust, that he sought to suggest that there's a malicious intent behind this legislation, that he dares to suggest or to argue in the face of the Barbadian public that this administration is doing nothing more than trying to pass a piece of legislation so that as a government we can peer into their personal business, so that we could try to find out what they're thinking. He is suggesting that we intend to use this legislation as a political tool. But that is a form of intellectual dishonesty, because having read the legislation, as I have no doubt that he did, he would understand that before a search warrant can be issued, before a warrant for interception of communications can be issued, that several things must be exhibited and established with the court. You have to say who you are going to be into, whose communication you're going to intercept. You have to state what is the criminal offense that you are going to be investigating. In our consultation with the social partnership, a question was raised whether anybody was going to be exempted from this legislation. And the response given quite firmly and perhaps even sternly by the Prime Minister was that there will be nobody who is exempted from this legislation. There is no exemption. If you are either suspected, if on the ground of national security, or if on the ground that the police are investigating any of those very serious offenses, then anybody, whether you're a parliamentarian or any other thing, whether you're a judge, a police, a doctor, a lawyer, no matter who you are, the public good dictates that you must be investigated. So there's no exemption. But for the leader of the opposition to suggest that there's something pernicious behind what we're doing is nothing short of disgraceful. It is evident that he's trying to stir public sentiment against legislation that only a few months ago he said he would support. But he's also trying to throw red herrings across the trail. And who will these red herrings help, sir? The red herrings will only cause people to distrust the police, law enforcement, and indirectly then give support and succor to the criminal element. Mr. Speaker, I shudder to think that that is anywhere close to the mindset of the leader of the opposition. I'm sure he would not want to give succor and support to the criminal element. But I have to say that it is wrong, absolutely wrong of him to suggest that there is some motive, some improper motive here when we pass this legislation in this chamber. Let me say again, this legislation will have no impact at all on the vast, vast majority of law-abiding Barbadians. It will not. I would dare to say, Mr. Speaker, that there's no chance that any member of the public who is law-abiding will have their communications intercepted, because the police must be able to go, the commissioner must say to the court, this is the ground on which I want to intercept your communication. You are either suspected of being involved in a serious criminal offense, likely to be involved in a serious criminal offense. Those are the situations, sir. That does not put the average citizen at risk. But what is more important, Mr. Speaker, and it's important that I reiterate this in my closing arguments, these documents the application has to be made to the Chief Justice or such of the judges he may nominate. So the risk of using interception of communications for nefarious needs was greater, or will be greater, without this legislation than when we pass this legislation. Because this legislation requires that the authorities, the law enforcement authorities, go and upfront frankly say to the Commissioner of Police, this is what we want to do. This is who it impacts. But more importantly, they have to convince the judge that the other ordinary methods are not likely to work or are dangerous, will be dangerous for them to operate in. So in fact, Mr. Speaker, rather than having a casual, cavalier, laissez-faire approach to this, the requirements are in fact quite stringent. The Barbadian public has no need to fear the impact of this bill. I have no fear of it. I do not believe any of my cabinet colleagues have any fear of it, because we understand clearly who it is intended to go after. Mr. Speaker, I've said many times in this debate that we've come late to the dance. We've come late to the dance. This legislation and its sister piece of legislation, let me put it another way. The legislation enacted in those other countries have yielded significant results. We've done our research, and in none of those countries is there a murmur of anybody trying to use so-called wiretapping legislation for political gain. We've never done it, and we are not about that, sir. The transparency is there. The monitoring is there. And the Prime Minister has announced that we will, before we rise this evening, make the amendment that seems so important to the leader of the opposition. And we will say that the President will appoint them. The President will set the rates. The President will do all those things without the need to consult with us. And the reason we can say so immediately, without any debate, without any rancor, the reason we are willing and able to make this concession is because we understand that the monitoring process, the monitoring authority, operates ex post facto. The monitoring authority is not able to send anybody to go and get a warrant. The monitoring authority is not able to give anybody a warrant. The monitoring authority has a single role, and that is to investigate the use of wiretapping, interception of communications, to determine if its use is consistent with the law. And that is a role that is shared by both the judge of the High Court, because as I mentioned earlier, reports have to be submitted, and it is also the role of the monitoring committee. I certainly was comfortable with the way the legislation was drafted, but if it gives Leader of the Opposition any comfort, we've said no problem. Takes nothing off of us to make this concession to make you comfortable. Okay? So the president will be able to make the appointments, but we still maintain we can't tell the president who to appoint. But the important thing is that the widest net possible must be capable of being cast, and therefore the capacity of the president to appoint eminent individuals from across the region is something that we think is key and critical, and in itself ought to have given the Leader of the Opposition sufficient satisfaction that there was absolutely no risk of the monitoring authority getting into the weeds. Their job is to look at the search warrants, the interception warrants that have already been granted. They're not there at the early stage at all. For the most part, they will come at the end and just need to look to see whether the law has been abused. Mr. Speaker, I am pleased to be able to move this entire suite of legislation. We have to make a few amendments. We've just indicated one. There are one or two others that are typos. But I believe that these legislative pieces will help to put the criminal justice system in Barbados on a firmer footing. They will help to put the criminal justice system in relation to the new jury's provisions on a firm footing. And I can say to the court, I can say to this chamber, that one criminal judge said to me that they are so excited that these legislative changes have finally been made to the Juries Act because they've been calling for them for a long time. And they have said, with no disrespect intended, that as far as the dispensation of justice is concerned, the Juries Act probably means more to them than all of the other pieces of legislation that we're enacting. Because this Juries Act, in its current formulation, will plug a huge hole which ensured, as long as it existed, that justice was not properly meted out to individuals. Mr. Speaker, I therefore beg to move that the interception of communication bill be read a second time.
Question is that the aforementioned bill be read a second time. All those who are members in favor, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this House do not resolve itself into committee for further consideration of the bill.
You have, honourable member, who I beg that I leave the chair. Honourable member. Honourable, you have to beg that I leave the chair.
Well, implicit in it, sir, is that you would leave the chair.
I prefer
But
to be
for the
explicit,
avoidance
honourable
of doubt, for the avoidance of doubt, I ask that you leave the chair, thereby permitting this House to go into committee.
The question is that the speaker do not leave the chair and the House resolve itself into committee for the consideration of this bill. All those who are members in favor, please say aye. Those against, please say no. We think the ayes have it.
This Honourable House is now in committee. Yes, so proceed.
Mr. Chairman, I beg to move that clause one, the part one, stand part.
The question is that part 1, clauses 1 to 4 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part two. Clauses 5 through 14.
Mr. Chairman, I want to make a slight amendment to clause A, subclause 4, subclause D, to delete the word section and replace it with subsection. We really meant to say subsection, but we have section instead. So we want to amend this by substituting the word subsection for the word section. With that amendment, I beg to move that part 2 stand part as amended. That's what you mean when you say with that amendment.
The question is that part 2, clauses 5 to 14 as amended stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 3, clauses 15 through 24.
Mr. Chairman, I wish there are a number of instances in this part where the incorrect numbers have been used, and these are them. In subclause 1A, I want to substitute the word 7 for the word 6. B, that is subclause 1B, I want to delete the word 9 and substitute the word 10. And in clause 21 in subclause 2A, I want to delete the word 6 and substitute the word 7, and in B, delete the word 9, substitute the word 10. In subclause 6, I want to delete the word 6 and substitute the word 5. In subclause 7A, I want to delete the word or in the first place in which it appears. I move that part 3 as amended, stand part.
The question is that part 3, clauses 15 to 24 as amended stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 4, clauses 5 through 31.
Mr. Chairman, I beg to move that part 4 stand part.
The question is that part 4, clauses 25 to 31 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 5, clauses 32 to 37.
Mr. Chairman, I beg to move that part 5 stand part.
The question is that part 5, clauses 32 to 37 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
The first schedule.
Mr. Chairman, in the first schedule to the bill, we have an instance of surplusage, which is to say that we have extra words that mean the same thing. And we therefore want to delete from paragraph 13 the following words: the contrary to, those 3 words. The contrary to, I ask that they be deleted. And with that amendment, I beg to move that the first schedule be the schedule to the bill.
The question is that the first schedule as amended be the first schedule to the bill. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Second schedule.
Mr. Chairman, we've given the assurance that we will make the amendment suggested by the Leader of the Opposition, and therefore, in this schedule, wherever the word minister appears, we want to substitute the word president. So wherever the word minister appears, we want to substitute the word president. In paragraph 1, 2 of the second schedule, we want to delete the words retired judge referred to under subparagraph 1 and simply say commissioner. And in paragraph 7, we have a numbering issue again. We want to delete 7A. In subparagraph 2, the words paragraph 6, 7.1, and substitute the words subparagraph 1 or paragraph 6. And further, in 7B, in subparagraph 3, delete the words paragraph 6 or 6.7.1 and substitute the words subparagraph 1 or paragraph 6. I beg therefore to move that the second schedule stand part as amended.
The question is that the second schedule as amended stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Report.
That you do now report His Honor the Speaker the passing of one bill in committee.
The question is that I do not report to His Honor the Speaker the passing of one bill in committee. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Chairman of committees has reported the passing of one bill in committee. Honourable Member St. Joseph.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that the aforementioned bill be read a third time. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This is the
Honourable member,
we have to vote.
this bill is subject to a constitutional amendment, but therefore require a 2/3 majority.
Do the next station, then they pass in the second. I gotta do it at the pass in the second.
Mr. Speaker, I beg to move this bill be passed and cited as the Intersection of Communications Act 2025.
Yes, ma'am.
Honourable member, you know this will be put to a vote.
Yes, ma'am. No, we gotta make sure. Ms. Motley? Ms. Bradshaw?
Aye.
Mr. Marshall?
Aye.
Mr. Simmons?
Aye.
Dr. Duguid?
Aye.
Mr. Sutherland?
Aye.
Ms. Husbands?
Aye.
Mr. Abrams?
Aye.
Mr. Weir?
Aye.
Mr. Ford? Mr. Griffith?
Aye.
Mr. Jordan?
Aye.
Mr. Humphrey?
Aye.
Mr. Strong?
Aye.
Mr. Goodenough?
Aye.
Ms. McConney?
Aye.
Mr. Lynn? Mr. Gibbs?
Aye.
Ms. Moore?
Aye.
His Honor, Mr. Nero? Ms. Ford?
Aye.
Mr. Blackman?
Aye.
Mr. Davison? Ishmael, sorry.
Aye.
Dr. Springer?
Aye.
Ms. Cottle?
Yes.
Mr. Prescott? Oh, he wasn't there. He wasn't there. Mr. Phillips? Hey.
Everybody.
Mr. Speaker, 27 honorable members voted. 27 honorable members voted in favor of the bill. There were no noes or abstention. This therefore satisfies the two-thirds threshold under the Constitution.
This bill having passed the threshold required by the Constitution now stands passed.
Mr. Speaker, order number 1, in the name of the Honourable Attorney General, to move the second reading of the Firearms Amendment Bill 2025.
Honourable Member for St. Joseph.
Mr. Speaker, I beg to move this bill be read a second time.
The question is that the bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Firearms, sir? Mr. Speaker, I beg to move that you do now leave the chair, for sure, and that this House resolve itself into committee for further consideration of this bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
This House is now in committee.
Clause 1.
Mr. Chairman, I beg to move that clause 1 stand part.
The question is that clause 1 stand part. All honourable members in favour, say aye. Honourable members against, say no. We think the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part. All honourable members in favour, say aye. Honourable members against, say no. We think the ayes have it.
Mr. Chairman, I beg to move that clause 3 stand part.
The question is that clause 3 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now leave the chair and report to His Honour the Speaker the passing of one bill in committee.
The question is that I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The chairman of committees has reported the passing of one bill in committee. Honourable Member St. Joseph.
Speaker, I beg to move that this bill be read a third time.
The question is that this bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move this bill do now pass and be cited as the Firearms Amendment Act 2025.
The question is that the bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Order number 2, sir. In the name of the Honourable Attorney General, to move the second reading of the Criminal Proceedings Witness Anonymity Bill 2025.
Honourable Member St. Joseph.
Mr. Speaker, I beg to move that this bill be read a second time.
The question is that the bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. Honorable member St. Joseph.
Mr. Speaker, I beg to move that you do now leave the chair and that this House resolve itself into committee for further consideration of the bill.
The question is that the Speaker do now leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
This Honourable House is now in committee.
Mr. Chairman, permission to call the bill in parts.
Permission granted.
Part 1, clauses 1 to 3.
Mr. Chairman, I beg to move that part 1 stand part.
The question is that Part 1, clauses 1 to 3 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Part 2, clauses 4 to 12.
Mr. Chairman, I need to move a small amendment to clause 11.5. In that clause, I want to delete the word summary conviction and substitute the word indictment on the basis that we consider the nature of that offense to be so severe that it should not be done summarily. And we also want to delete the word to and substitute the word 10. I therefore beg to move that, as amended, part 2 stand part.
Betty, second that.
The question is that Part 2, clauses 4 to 12 as amended stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Part 3, clauses 13 to 27.
Mr. Chairman, I beg to move that part 3 stand part.
Betty, second that.
The question is that Part 3, clauses 13 to 27 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Part 4, clauses 28 and 29.
Mr. Chairman, I beg to move that part 4 stand part.
Betty, second that.
The question is that Part 4, clauses 28 and 29 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Schedule.
Mr. Chairman, I beg to move that the schedule be the schedule to the bill.
Betty, second that.
The question is that the schedule be the schedule to the bill. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Mr. Chairman, I beg that you do not report His Honour the Speaker, the passing of one bill in committee.
Betty, second that.
The question is that I do not report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The chairman of committees has reported the passing of one bill with amendments in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Betty, second that.
The question is that this bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Criminal Proceedings Witness Anonymity Act 2025.
Betty, second that.
The question is that this bill be passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Order number 3, sir. In the name of the Honourable Attorney General, to move the second reading of the Police Amendment Bill 2025.
Honourable member for St. Joseph.
Second that.
The question is that this bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Betty second that.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye.
Mr. Speaker, I apologize.
off.
It appears as though the microphone was off. I think I've stood on my foot too many times for the day. I beg to move for the record that this bill be read a second time.
I beg to second that with my
The
microphone
question
on
is
this
that the
one.
bill be ready a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do not leave the chair and that this House resolve itself in the committee for further consideration of the bill.
The question is that the
Betty,
Speaker do
second
not
that.
leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This Honourable House is now in committee.
Mr. Chairman, permission is sought once again to call in groups of clauses, please.
Permission so granted.
Clauses 1 to 10.
Mr. Chairman, I beg to move that clauses 1 to 10 stand apart.
Betty second that.
The question is that clauses 1 to 10 stand apart. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Clauses 11 to 15.
Mr. Chairman, I beg to move that clauses 11 to 15 stand apart.
Betty second that.
The question is that clauses 11 to 15 stand apart. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Clauses 16 to 25.
Mr. Chairman, I beg to move that clauses 16 to 25 stand apart.
Betty second that.
The question is that clauses 16 to 25 stand apart. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Clauses 26 to 32.
Mr. Chairman, I beg to move that clauses 26 to 32 stand apart.
Betty second that.
The question is that clauses 26 to 32 stand apart. All honourable members in favor, say aye. Honourable members against, we say no. Methinks the ayes have it.
First schedule.
Mr. Chairman, I need to move a slight amendment to the first schedule to the bill. In error, we didn't make it clear that it was either you swear by Almighty God or you solemnly and sincerely affirm. We had the word "and" in there instead of "or," and that occurs in both Form A and Form B. So in Form A, I am moving that the words "do swear by Almighty God" and "do hereby solemnly and sincerely affirm" be deleted, and that we substitute the words "swear by Almighty God" or "solemnly and sincerely affirm." And I ask that the same amendment be made in Form B, but for the record, that we delete the words "do hereby swear by Almighty God" and "do hereby solemnly and sincerely affirm," and substitute therefore the words "swear by Almighty God" or "solemnly and sincerely affirm." I therefore beg to move that the first schedule as amended be the first schedule to the bill.
Betty second that.
The question is that the first schedule as amended be the first schedule of the bill. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Second schedule.
Mr. Chairman, I beg to move that the second schedule be the schedule to the bill, to the second schedule to the bill.
The question is that the second schedule be the second schedule to the bill. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Come in. not leave the chair. Sorry, that you do not report his honor the speaker the passing of one bill in committee.
The question is that I do not report to His Honor the Speaker the passing of one bill in committee. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
The chairman of committees has reported the passing of one bill in committee. Honourable member for St. Joseph.
Mr. Speaker, I beg to move that this bill be read a third time.
Basic.
Question that this bill be read a third time. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Beg to move that this bill do not pass and be cited as the Police Amendment Act 2025.
The question is that this bill be passed and so cited. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Order number 5, sir. In the name of the Honourable Attorney General, to move the second reading of the Jury's Bill 2025.
Honourable member for St. Joseph.
Mr. Speaker, I beg to move that this bill be read a second time.
The question is that the bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. All members for St.
Speaker, I
Joseph.
beg to move that you do not leave the chair and that this House resolve itself into committee for further consideration of the bill.
The question is that the speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
This honorable House is now in committee.
Mr. Chairman, permission once again to call in parts, please.
So granted.
Part 1, clauses 1 and 2.
Mr. Chairman, I beg to move that Part 1 stand part.
Better second that.
The question is that Part 1, clauses 1 to 2 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 2, clauses 3 to 6.
Mr. Chairman, I beg to move that Part 2 stand part.
Better second that.
The question is that Part 2, clauses 3 to 6 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 3, clauses 7 to 11.
Mr. Chairman, I beg to move that Part 3 stand part.
The question is that Part 3, clauses 7 to 11 stand part. All honorable members in favor, say aye. Honorable members against, please say no. Methinks the ayes have it.
Part 4, clauses 12 to 16.
Mr. Chairman, I beg to move that Part 4 stand part.
The question is that Part 4, clauses 12 to 16 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 5, clauses 17 to 23.
Mr. Chairman, I beg to move that Part 5 stand part.
The question is that Part 5, clauses 17 to 23 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 6, clauses 24 to 28.
Mr. Chairman, I beg to move that Part 6 stand part.
The question is that Part 6, clauses 24 to 28 stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 7, clauses 29 to 36.
Mr. Chairman, I beg to move that Part 7 stand part.
Better second that.
The question is that Part 7, clauses 29 to 36, stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Part 8, clauses 37 to 45.
Mr. Chairman, I beg to move that Part 8 stand part.
Ready, second that?
The question is that Part 8, clauses 37 to 45, stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
Schedule.
Chairman, I beg to move that the schedule be the schedule to the bill.
Ready, second that?
The question is that the schedule be the schedule to the bill. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
I beg to move that you do not report to His Honor the Speaker the passing of one bill in committee.
Ready, second that?
The question is that I do not report to His Honor the Speaker the passing of one bill in committee. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
The chairman of committees has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
The question is that the bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Juries Act 2025.
Ready, second.
The question is that this bill be passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
You've heard the papers, sir.
Honorable member for St. Philip West.
Mr. Speaker, I'm commanded to lay the amended jury contract number 5908/0CBA, amendment number 1 to the Barbados Climate Resilient South Coast Water Reclamation Project, and the loan contract number 5985/GN-BA, the Barbados Climate Resilient South Coast Water Reclamation Project, and to the non-reimbursable investment financing agreement number GRT/GN-21498, the Barbados Climate Resilient South Coast Water Reclamation Project.
Recommittal of government notices, sir.
Honorable Leader of Government Business.
Thank you, Mr. Speaker. I beg to give notice of the Barbados Citizenship Bill 2025 and the Immigration Bill 2025.
Recommittal, first readings of bills.
Honorable Leader of Government Business.
Speaker, I beg to move the first reading of the Barbados Citizenship Bill 2025 and the Immigration Bill 2025.
The question is that the aforementioned bills be read a first time. All honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. Yeah. Friday. It's Friday, forget. It's Friday night. It's Friday. Honourable Leader, Government Business.
Speaker, I beg to move the first reading of the Barbados Tourism Product Authority Repeal, Transfer of Assets and Liabilities Act 2025. Why is this the act? Act? It's not it. Bill 2025 and the Tourism Accommodation Bill 2025.
Question that the aforementioned bills be read your first time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. Honourable Leader, Government Business.
Thank you, Mr. Speaker. With that, we've come to the end of today's sitting. I therefore beg to move the adjournment of the House until Tuesday, the 12th of August at 10 a.m.
May I second that?
The question is that this honourable chamber be adjourned until Tuesday, the 12th day of August, 2025 at 10 a.m. in the forenoon. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. This honourable chamber stands adjourned until Tuesday, the 12th day of August, 2025 at 10 a.m. in the forenoon.